Good morning, and thank you for joining me on the Path to Liberty. This is the Fast Friday edition of the show for March 6th, 2020. On this episode, we're once again talking about the unconstitutional federal bump stock ban and the latest failure to protect liberty in the federal courts. First of all, my name is Michael Bolden. We broadcast live every Monday, Wednesday, and Friday at 9:30 a.m. Pacific time from here in my home office and studio in downtown Los Angeles for the 10th Amendment Center. You can find all of our live streaming video platforms, plus the archive-only video platforms, and also all the audio-only podcast editions, plus ways to follow us, show notes, links to stuff that I mention in each episode. Ways to support us, like our membership program for as little as $2 a month. Find all of that over at 10thamendmentcenter.com/path to liberty. That's all spelled out. 10thamendmentcenter.com/path to liberty. Now, I could not be more grateful for you spending a few minutes of your time with me today as we wrap up the work week and get into the weekend. I can't thank you enough. But I promise, since it's the Fast Friday edition of the show, not to take up too much of your time. Let's see if I can get this done in about 10 to 15 minutes. And as a quick backgrounder on this, I've done at least three off the top of my head, 3 episodes on this bump stock ban. First of all, and I recommend if you have not checked these out yet, or maybe you want a refresher, to go back to them. Of course, I will link to those in the show notes when I publish them in the next half hour to an hour after the live stream is done. But first of all, back in October of 2018, talking about the proposal from the administration to actually put this out there. They were drafting it up. It had been going through the process, and we were expecting it to happen pretty soon. So I covered that in some detail. Then I did a follow-up once it actually was rolled out, and when they were talking about implementing it a few months later. That's the unconstitutional bump stock ban and what to do about it. So I talked about that in December of 2018, what needs to happen. And that's so incredibly important. We'll touch on that a little bit later in this episode. And then finally, I did my 3rd episode in October of last year, on October 9th of 2019, reporting on some dismal compliance and enforcement numbers, which is a positive sign. But I think that's also an important part of the overall strategy. Now, let's take a look at how this has been implemented. And I first want to mention, and this link will be in the show notes as well, again, the unconstitutional bump stock ban and what to do about it. This is what I covered in that episode in December of 2018. But it's important to note that the Obama administration actually considered doing the same thing. They looked at the process for this. Can we take existing law and rather than go to Congress and ask them to pass a new one, not that that would be constitutional in the first place, but they looked at just redefining the bump stock to fit within laws that Congress had already passed, and they said they couldn't do it. Check this out. This is the Obama administration's ATF technology chief who wrote this. I wish I had the name handy, but they said the stock has no automatically functioning mechanical parts or springs and performs no automatic mechanical function when installed. Accordingly, we find that the bump stock is a firearm part and is not regulated as a firearm under the Gun Control Act or National Firearms Act. That's the GCA of 1968, its amendments as well, and the National Firearms Act of 1934. Now, keep in mind, none of these federal gun control measures should exist in the first place. The number that are authorized, the number of federal gun control measures that are authorized under the Constitution, and of course, the Second Amendment to that Constitution, is exactly 0. So none of them should exist. The ATF, everyone who works there should get a real job. But here's Obama, his administration saying, look, we can't do this. We'd like to, but we can't. But that's exactly what the Trump administration decided they could do. Even though Obama, the great gun grabber out there, couldn't do it or decided against it on their own, the Trump administration went in and redefined things and basically have defined a bump stock, an accessory, what some people would call disparagingly a kiddie toy, a plastic kiddie toy. And now they're saying that's a machine gun. Now, it doesn't take an imaginative person to think what kind of thing someone in the future will do with that type of precedent. So this is incredibly bad in my view. Now, mind you, the Obama administration did try to set this kind of precedent with the M855 green tip ammunition. They tried to ban it through an agency rule, basically redefining things to say that now this is going to be banned. But there was a lot of opposition from the opposition party at the time. But these days, the opposition party doesn't exist when it comes to violating the right to keep and bear arms. So the Trump administration decided what it could do, what the Obama administration said they couldn't. They redefined this kiddie toy, this accessory. Maybe for some people it's incredibly important, but the bump stock, and redefined it as a machine gun to ban it under the NFA and or the Gun Control Act. Now, Trump had almost no resistance. So let's fast forward. Most of the so-called Second Amendment organizations out there said almost nothing about this. Now, there were a few that actually went out of their way. But like, for example, the NRA, absolutely not a peep, really. They didn't like the process, is the only thing that I found on it. But there was very little resistance to it. There were some lawsuits, of course. I believe the two big ones are from Gun Owners of America and then from FPC, Firearms Policy Coalition. And last April, the case, and this was from Firearms Policy Coalition, the case is Guedes, Guedes. I apologize if I get that name wrong. Guedes versus the BATF, Bureau of Alcohol, Tobacco, and Firearms, which really should be a corner convenience store. The U.S. Court of Appeals for the D.C. Circuit upheld the Trump administration's ban. So the Court of Appeals in the D.C. Circuit already said, well, you guys can do this. And then on Monday, check this out in Reuters, the U.S. Supreme Court this past Monday, this is March 2nd, 2020, rebuffed a bid by gun rights advocates to overturn President Donald Trump's ban on bump stocks. The justices left in place a lower court's decision that upheld the Trump administration's action to define bump stocks as prohibited machine guns under U.S. law, even as litigation over the policy continues. Now, this is not the end of the story for the court cases, but it is a huge setback. And of course, now we're talking about we're well close to a year and a half. By the time this ever gets heard again, we're talking 2+ years before this whole thing works out. And people are having their rights violated for 2 years while we're waiting for permission from Washington, D.C. Now, over in the Blaze, they have a little bit more detail on what was really going on. It wasn't that they were necessarily saying, now it's a tricky situation because the case wasn't just cut and dry about whether or not this was an authorized action under the Constitution. There's something called the Chevron Defense. And here over at the Blaze, they put it this way. The term was coined after the 1984 Chevron versus NRDC ruling opinion, which provided a framework for when courts should defer to federal agencies' quote, reasonable interpretation of vague laws passed by instead of imposing their own. So in essence, what happens, the Chevron defense is if a federal agency defines something that isn't maybe super clearly defined by Congress and there's some kind of latitude on how you might read this, instead of the courts actually giving their opinion, they won't even touch it. I mean, not that the court actually decides what is and is not constitutional, but they are authorized to give their opinion on something. And they basically just say, well, we're just going to defer to the federal agencies, which is an unelected, unaccountable bureaucratic body. And what this leads to is what we have now with this bump stock ban. It gets way too much power for these agencies. Going further, in their petition for the Supreme Court to take up the case, the plaintiffs argued that lower courts had incorrectly applied Chevron precedent in upholding the bump stock ban and should have instead applied a different, less deferential standard for evaluating. This is some wonky garbage. I mean, if you're just suing over this thing, you're taking it to court, and if this is all you got is some, well, they applied this Chevron defense right or wrong, I don't think it's a really good strategy. And in fact, I'll get to that in just a minute. Now, going further over at the Blaze, in an opinion explaining why the petition was denied, Justice Neil Gorsuch agreed with the idea that a lot of people I've seen reporting that Gorsuch was kind of hammering on this, but he was on board with the idea that the Supreme Court should reject even hearing this. So he may not be that awesome, but anyways, he had some good statements. But in general, he was on board with saying the Supreme Court shouldn't take this up. I think it's an incredibly important issue, and it's an incredibly important precedent, and for them to just turn it down is incredibly bad as well. So he agreed with the idea that the Chevron deference had been incorrectly applied, noting that even the administration had asked the lower court to waive it. He said, you know, this is something we probably want to consider. We think this is very important. In fact, he said waiting should not be mistaken for a lack of concern over what's going on. So maybe he's good, maybe not, but the bottom line is they're not touching it, and he agreed with their reason to not touch it as well. And this is some of the good stuff that he says. The agency used to tell everyone that bump stocks don't qualify as machine guns. Now it says just the opposite. Think of the problems that creates. Thank you, NRA-backed president. He goes on, the law hasn't changed, only an agency's interpretation of it. And these days, it sometimes seems agencies change their statutory interpretations almost as often as elections change administrations. Well, that, I think, is pretty clear. He goes on, why should courts charged with the independent and neutral interpretation of the laws Congress has enacted defer to such bureaucratic pirouetting? However, the justice agreed with his colleagues that the court should wait, and that in and of itself is a huge problem. Now, of course, we've basically got everyone telling us, wait, okay, wait for the courts to do this, wait for the next round of court action. No one is actually following the advice of James Madison, the father of the Constitution, who in Federalist 46 gave us a 4-point plan. And this 4-point plan, he said the states and the people, the means of opposition to an unconstitutional act, or even a constitutional but unpopular act, he said, are powerful and at hand. So he gives 4 steps on this, and I will include a link to this. I've covered this pretty much at length on this show, but I will cover, I'll put a link to this article in the show notes so you can read through it. There are 4 steps. Not one of them is first sue the federal government in the federal courts in the hopes that the federal judges will tell the federal government that the federal government is wrong and that you now have federal permission to exercise your rights. Nowhere even close in Federalist 46 do you see Madison saying things like this. He says the disquietude of the people. I'll just go through them briefly. This is people being really pissed off, being upset. 2, repugnance and a refusal to cooperate with officers of the union. A refusal to cooperate with the officers of the union. One quick aside on that is that the word repugnance, if you look it up in a dictionary of the time, really actually meant disobedience. So when we're talking about a refusal to cooperate with officers of the union, that's when states and localities don't participate in the enforcement. But the repugnance of the people, that's saying disobey. And thankfully, we're seeing at least some of this happen. I have not seen a follow-up on it yet, but I did cover how there is a very low compliance rate in that episode back in October that I've pulled up on the screen here. Bump stocks, will the people nullify the ban? From my understanding, a lot of that non-compliance was due to organizations involved in a lawsuit saying, look, don't just jump in and start participating or turn your bump stock in. We're going to see how this plays out in court. So we're going to have to kind of watch and see where that goes in the coming, we'll say year or so, months to years. 3, frowns of the executive magistracies of the state. These are the governors. They're supposed to be very outspoken. And then 4, state-level legislative devices, which would be added on these occasions. And none of these 4 steps that Madison advised to defeat federal programs include first going to federal court, seeing how it plays out, hoping that the federal judges side with you against the federal government, and then later on figuring out what you're going to do. No, first what you're supposed to do, even if you're going to do a lawsuit, and I'm not saying don't ever do lawsuits. Some organizations, that's what they're best at. But this is not a way to advance liberty, sitting around on your hands, on your butt, throwing money at some organization to get involved in a lawsuit, which keeps losing and losing and losing, I think is a recipe for disaster. Well, I hope you guys found this interesting. I hope you found it educational. The most important thing, of course, did you learn something? I learned things as I keep going through this. I'm learning more and more about things like the Chevron Defense. I think I should probably do an episode on that sometime, maybe not in the near future, but maybe sometime this year. If you find it interesting, please do let me know, whether in the comments or feel free to email me about that or any other show suggestions at team@10thamendmentcenter.com. Of course, if you support the show and you like what we're doing, smash the like button on whatever platform you're on. Leave a review where you're able to do that, like iTunes or Spotify, things like that. And if you really want to pitch in, some financial support goes a long, long way. I'm stumbling over my own ad here. 10thamendmentcenter.com/members. Our membership programs start as little as $2 a month. And we really, when a bunch of people pull together, we make that money go a long, long way so we can get the job done and continue to grow and reach more people. Well, again, I appreciate you spending some time with me today. I hope you have a great weekend, and I'll see you next time here on the path to liberty.